Good morning, everyone. Welcome to Landmark Chambers Repowering Onshore, Planning for Onshore Wind in England, Wales and Northern Ireland. We are delighted to see so many of you with us this morning and hope you'll find our presentations and discussions to be useful and informative. I'm David Elvin, Queen's Counsel. I'm going to chair the session today. I'm joined by Rebecca Williams from Renewable UK and my colleagues Matthew Dale-Harris and Heather Sargent, and I'll also be providing a short presentation at the end of the presentations on onshore wind in Northern Ireland. Rebecca, who we're delighted to have joining us today, leads Renewable UK's work to develop policy and engage stakeholders on the next stage in energy transition. She specialises in market design, working closely with governments and regulators to effect change that will deliver renewable energy at the scale needed for net zero. In addition to mature renewables like onshore and offshore wind, Rebecca also leads Renewable UK's work to create the right policy framework to bring about innovative technologies such as floating offshore wind, tidal energy and electricity storage to market. Just a couple of housekeeping points before we start. Please note that your microphones are automatically muted, so you won't need to adjust your local settings. We very much welcome questions throughout the session, and please submit any questions via the Q&A section or tab, which you'll find either at the top or bottom of your screen. We'll try and answer all your questions following the last presentation, but if we're unable to do so in the time available, we will follow up by email after the event. Please note that if you lose your connection during the webinar, just rejoin by clicking again on the link that was sent to you earlier. Thank you. I'm now going to hand over to Rebecca to present the first paper. Rebecca's having bandwidth problems this morning, so she'll only be joining us in audio unless the situation improves.
Thanks, David, and yeah, apologies again. After behaving perfectly for months on end, my Wi-Fi has chosen this moment. It forced me to give you a bit of context around the policy for onshore wind in this presentation before the rest of the panelists will take you through the planning side of things in detail. So a bit of obligatory background first of all about Renewable UK. So hopefully you know that Renewable UK are the leading trade association for the future of the electricity system, and our membership encompasses around 450 members from across the industry. So that's from business leaders right through to smaller and medium enterprises in the supply chain. So we encompass the supply chain as well as the development community too. Our members are operating throughout the UK and across the world, and increasingly exporting goods and services to around 37 countries across a range of sectors. And I think the important thing to note now is that many of our members are moving into what we would call kind of the smart energy future. So increasingly they're focusing not just on pure development of wind sites, but they're also looking at how you could co-locate that with storage, looking at how they play in multiple different markets. I just wanted to give you a bit of context around the energy system in the UK in general, and the role that the CfD has had in bringing forward the cost reductions that we have seen, and also the large volume of renewables that we've seen deployed in the UK to date. And I think the main thing to note here is that since the 2015 written ministerial statement on onshore wind has not been eligible to bid into the contracts for difference regime. The contracts for difference regime is the UK government's main vehicle for procuring renewable energy. And we've seen through what's happened in the offshore wind space that the CfD has played an instrumental role in driving that technology innovation and in bringing those costs down. So this slide really looks to capture how we have greened our power system from 2012, and you can see up there in the top left, all the black basically represents coal. It represents the CO2 emissions of our power sector. And in the UK, we have done a great job at decarbonising our power sector. But over the last few years, we have seen large volumes of offshore wind deployed, but we haven't seen the corresponding level of onshore wind or even much onshore wind at all. And that has been down to a few things, which we'll come on in to discuss in more detail later in this presentation. But one of those is the planning system, which was changed as part of the 2015 ministerial statement. And the other is the CfD. So just so you're aware, the CfD energy policy is not a devolved issue. So the control for that system rests with the Westminster government. However, planning, as I'm sure you'll come on to discuss, is a devolved issue, and each of the devolved nations has their own planning framework. So when we're looking at onshore wind and how the deployment of onshore wind has happened over the last few years in the UK, we need to bear in mind those two factors, that part of the reason that we haven't seen very much deployment at all over the last few years is because of the restrictions on planning in England, but also the lack of access to the CfD around the whole of the UK. However, there's some really good news which has come this year after many years of hard lobbying on behalf of Renewable UK and also of our members. We're really pleased to see the re-inclusion of Pot 1 contracts for difference auctions announced earlier this year. And it feels like absolutely ages ago, but it was actually just in March that happened. So absolutely delighted to see that change in policy, which I say has come about following a lot of hard work. And I think that's because the UK government really recognised that onshore wind has a role to play in helping us get to net zero. And increasingly looking towards the future, onshore wind has a really high level of UK content and has driven local employment opportunities in regions which have typically lower productivity. So it's a fantastic news story for communities up and down the UK, and it's also good for UK bill payers who on average stand to save around £50 per household per year by the re-inclusion of onshore wind in the CfD framework. So BEIS have just finished consulting on the next round of CfD auctions. This is allocation round 4. So the last time that onshore wind was included in the CfD, that was allocation round 1. So yeah, we've come quite a way since then. But this provides a great opportunity now to deploy more onshore wind and to take the industry forwards. So we are absolutely delighted about that. In the consultation, which has just closed, it closed a couple of weeks ago, one of the main elements that was being consulted on was around provisions for community support with respect to onshore wind. And I think it's important to note that the consultation itself was not consulting on whether or not to allow onshore wind back into Pot 1. That decision has been taken, and the consultation was a way to kind of announce that change. But BEIS are consulting on the community support and how we can adequately respond to the needs of local communities, and how that and how any guidance across devolved nations could be streamlined and take into account the needs of those communities whilst balancing that with development. So a big feature of the consultation were the questions on community support. And you can see from this slide here a summary of the consultation questions and also a summary of the proposals and what BEIS are trying to achieve with this section. So one of the questions here was around the creation of a register of renewable energy development in England, and welcoming examples and suggestions of how to improve engagement and examples of best practice in dealing with communities around the UK. And I don't think as yet as such that BEIS are proposing that the community provisions would necessarily be strongly linked to the CfD, although this is a start of a conversation as far as I understand it. and there could be further consultation on some of these matters. So really, I think this part of the consultation is to provide reassurance to politicians and ministers and local communities that their needs are being strongly taken into account in the resumption of Pot 1 contracts for difference auctions. So the other thing that BEIS are consulting on as part of their discussions around allocation round 4 is that there would be an additional pot for offshore wind. So in the past, there's been 2 pots in the CfD. There's been Pot 1, which is for more established technologies like onshore wind and solar, and there's been a Pot 2, which is for less established technologies, including offshore wind, remote island wind, advanced conversion technologies, and wave and tidal. Now, there's been a lot of discussion around the best way for the government to take forward innovative technologies, and also to take forward their targets around net zero, so 75 gigawatts of offshore wind by 2050 is the figure that the Committee on Climate Change had, and also the Conservative government set their own target of 40 gigawatts of offshore wind by 2030, and to enable new floating offshore wind turbines. So because of those strategic priorities, BEIS is now consulting on a change to the pot structure, which would see Pot 1 include onshore wind, solar PV, etc. Then Pot 2, which would be less established technologies such as floating wind, wave and tidal, remote island wind. And then Pot 3, which would be offshore wind. And I think there was quite a lot of discussion around whether to just merge the pots and have kind of technology neutral auctions ahead of this, which would see onshore wind potentially competing with offshore wind, for instance. But I think given BEIS's strategic priorities and ministerial priorities, they believe that having this 3-pot approach is the best way to help them achieve those goals. What Renewable UK has been calling for with regard to onshore wind during this process is that we are now trying to do a bit make up for lost time with onshore wind, and we do have these really high targets for renewables which have been set by the net zero target. So what we'd like to see is that the auction parameters and structures are such that they would enable the deployment of onshore wind in line with net zero. And so that then kind of leads us on to the question, well, what is the potential for onshore wind in the UK? So at Renewable UK, we have an in-house project intelligence model, and if you join as a member of Renewable UK, you have full access to our project intelligence database, which tracks onshore wind in the UK, and including Northern Ireland. I say including because there is a slight different approach in Northern Ireland, as they're not included in the contracts for difference at the moment. And it tracks offshore wind globally, as well as now hydrogen and battery storage projects too. But from that, we were able to build a model which looks at onshore wind future deployment scenarios. So this chart that you can see in front of you illustrates our high scenario for onshore wind growth. And that shows that we see significant growth in onshore wind, with capacity growing to 26 gigawatts by 2030 and potentially 36 gigawatts by 2050. We see around 20 gigawatts of that in Scotland by 2050, and we see the majority of capacity procured through government-backed mechanisms like the Pot 1 CfD. We're also counting on taller turbines, a favourable planning regime, and participation in ancillary services markets. So that's markets that are run by National Grid ESO to help balance the grid, and other competitive market frameworks to enable project developers to then be more competitive in their bidding. So I think this takes us nicely onto what we are going to discuss today, because you can see that a lot of that capacity is in Scotland, and we anticipate that new build capacity will increasingly be in Scotland and in Wales, where wind speeds are higher, and therefore, we can make the most of more economic projects and capitalise on those higher wind speeds. But you can see that in this chart, we assume a high rate of the repowering of sites, and you can see that represented in the green section of the chart here. And I think what's interesting is that the other scenarios and models that we have in front of us from people like the Committee on Climate Change just absolutely assume that repowering of sites in the UK will take place. But without a favourable planning regime that allows for the repowering of onshore wind sites, we do stand to lose a lot of capacity. In fact, we stand to lose about 8 gigawatts of capacity by 2040 if we don't get a favourable repowering regime. And the team from Landmark are going to take you through this in more detail in a moment, but I just want to leave you with that point, that it's absolutely crucial that we do repower sites in the UK in order for us to meet our climate goals, even bearing in mind that we will see new capacity come forward through the CfD. By itself, that new capacity is not going to be enough to get us to those high levels of renewables that we'll need for net zero. So David, I'll leave it there and I'll pass on to the rest of the team now, but obviously I'm happy to take any questions later.
Thank you. I'm now going to hand over to Matt Dale-Harris, who's going to deal with issues in planning in England under the NPPF. Thanks, Matt.
Thank you very much, David. I'm going to be looking at, as David said, the planning position in England. Now, we know, I think, or it will be familiar to many of you, but I'm going to touch on that in England, since the written ministerial statement in 2015, the planning regime has been very challenging for any new schemes. Obviously, a position that's been made even worse by the absence of onshore wind from the CfD allocation rounds. However, repowering has now, since July 2018, been an option in England under the framework. So the focus of this talk is really going to be, first, to give you a brief introduction, a brief overview of the NPPF and the consenting regime, and then really focus on repowering. I've got 4 kind of key practice points for people looking to bring forward schemes, and then I'm going to touch briefly on local development plans as just another aspect to this problem for developers looking to bring forward projects. So firstly, the overview. Now, since the 2016 infrastructure planning onshore wind generating stations order, onshore wind in England has been excluded from the nationally significant infrastructure projects regime. So you can't get a DCO for it. The 50 megawatt threshold that may be familiar from other generating contexts doesn't apply. So your decision maker in England is always going to be the local planning authority. The decision making framework will be that set out within the Town and Country Planning Act. And the key policy framework document will be the NPPF, which obviously needs to be read alongside any other guidance from the NPPG, as well as anything in the statutory development plan and other material considerations. The NPPF, now at footnote 49, contains the policy that was originally set out in June 2015. New schemes will only be acceptable if it can be shown that they're in an area which has been identified as suitable in the development plan, and it can be demonstrated that planning impacts identified by local communities have been fully addressed and the proposal has their backing. Given the context of onshore wind and the difficulties which many developers have found have run into in mollifying local groups, those 2 tests place a very high barrier, very high hurdle for new onshore wind schemes. However, following engagement from the industry, the original position as set out in the WMS was was modified in July 2018, and since then applications for repowering of existing wind turbines are exempted from the requirements I've laid out above. So given that context, and I think as Rebecca's slides made very clear, repowering in England is going to have a very important role to play, both in maintaining and increasing the onshore contribution which can be made, particularly within England. So my first practice point is that any developer coming forward into this area, bidding for contracts under the CfD, is going to need to think about the options for repowering of particular wind farms in which they have an interest. So first question really is, well, what is repowering? Unhelpfully, it's not defined in either the NPPF nor the online PPG. It is discussed in the National Policy Statement, which still exists, which is EN3, that's the English National Policy Statement. Although, of course, that doesn't any longer apply to schemes because we no longer have DCOs coming forwards. And it's also discussed in the Scottish guidance. Renewables UK, in their 2019 paper, talk about 4 main forms of repowering. Firstly, life extension, when you apply to extend the permitted operational period of any given scheme. Refurbishment, kind of next stage up, where you might be looking to repair or renew aspects of the turbine, aspects of the maybe the blades, but you're not changing the structures. Replanting, where you might think about replacing the turbine itself, potentially adding longer blades, but normally you wouldn't be replacing the towers. And critically, you're going to keep your turbines on their existing foundations, and will be using the existing infrastructure. And then finally, full repowering, as Renewable UK describe it, which is really when you're redeveloping the site in such a way that you can't use the existing infrastructure or very little of it. You're going to need new foundations. You're going to be putting in probably bigger turbines, almost certainly larger turbines, taller turbines, which will require a different layout, possibly over a larger area, but certainly with, but potentially also with fewer turbines. There hasn't been, in terms of what you can get away with, there hasn't been very much discussion as yet, either by the planning inspectorate and none in the courts. And really the only appeal decision which provides any guidance is that from July last year at Kirkby Moor. That scheme, as considered there, was a life extension scheme. It was the sort of second go because the developer had already applied for a more substantial replanting repowering scheme, which had been rejected by the local authority and not appealed. So the issue at appeal was whether or not the life extension would fall within the definition of repowering for the purposes of footnote 49. And the local authority, slightly surprisingly, accepted that replanting or indeed replacement of turbines would be repowering, but they argued that life extension itself wasn't. The inspector rejected that argument and held that the appellant's argument that repowering included replacement, replanting and extension was persuasive. So that's probably quite a good basis for any of you who might be arguing that point out with local planning authorities. The other issue I think that's going to arise going forward, and particularly where you're seeking to bring forward repowering schemes in areas where local authorities perhaps might not be very keen on them, is the extent to which a repowering scheme can be said to be a repowering of the existing turbines if it changes the red line boundary, it changes the footprint. Now here, the national policy statement in its discussion of repowering is, I think, quite helpful, because it says that repowering will normally involve changes in number and size of turbines. And we know that in reality that almost certainly means that the layout of the wind farm and its extent is going to have to change. So I think there's a good basis for saying that change in the red line boundary is not going to be necessarily a problem, although that is perhaps an issue that will be contentious. Local authorities may argue it's not a repowering scheme. So the key points that I think you're going to want to think about as you're shaping your schemes, as you're bringing them forwards, is to think about its impacts, its environmental impacts. I think it's going to be inevitable that there are going to be significant changes in the EIA, in the approach that's taken under any new EIA, but so far as possible, I think developers should seek to align the scope of the impacts that might be generated by the repowered scheme with those that were experienced and that were assessed under the original EIA. I think that will be a very useful point for showing that this is a repowering of that existing scheme. Think about how to justify any expansion. I think there will be an element of judgment in how local authorities approach repowering until such time as the courts have to consider it. So think carefully about how you're going to justify it, what the technical issues are that require a change, and then consult as far as you can with the authority in advance of putting your scheme in as an early stage as possible. My second practice point is about trying to get as much benefit as you can out of the fact that there is an existing scheme on the site, and how that can play into the arguments that you make in support of the scheme. And I think the first point is that the historic consent provides something of a roadmap towards how consent can be granted in this case, and is potentially also a strong basis. The existing scheme is a strong basis on which you can evidence the impacts of any repowered scheme. It provides, you are likely to have far more information about this site and about the impacts that wind turbines can have on it, because you have been studying the scheme. You have information about the scheme that's been acquired over the time that the previous scheme has been operational. For example, and I have to thank here Chris Calvert from Pegasus, who very kindly, who was the planning consultant on the Kirkby Moor appeal, and who very kindly gave me some of his time in preparing these slides to have a discussion about what happened at Kirkby Moor. I know there that there were hydrological issues that had been raised, and the team promoting the scheme were able to address that because they were able to draw on a series of reports, on a series of studies going back over time, in a way that perhaps wouldn't have been possible on a fresh scheme. Now, another point also that arose at Kirkby Moor is that the extant scheme, you can look at it quite carefully and you can see where there may be areas to add additional value on what was agreed when granting that original consent. So I think Renewables UK in their 2019 paper made the point that many of the earliest schemes didn't have, some didn't have decommissioning obligations at all, and many had decommissioning obligations which would be considered dated by today's standards. So there's an opportunity there, if the developer can point to weaknesses in what it's currently obliged to do, to provide additional value which can be taken into account in justifying the scheme in terms of improved decommissioning plans. And at Kirkby Moor, that included an enhanced habitats plan, which showed how, following the life cycle of the extended scheme, there would be an improvement to the habitats position. However, the flip side, of course, in the limitation on relying on the extant scheme and the historic consent will be, of course, that the legal and policy framework have changed. And I wanted to note particularly the developments in EIA and habitats. EIA, as will be familiar to a lot of you, has evolved significantly since the 1990s. We've had a new directive, we've had a series of different iterations of the regulations, and obviously taller turbines are also going to potentially lead to quite different situations in terms of the zone of influence and the range of potentially affected receptors. And a particularly important point to identify in getting your EIA together is, of course, the aviation safety requirements, because lighting on the blades may be a significant component, a significant driver of impacts. Habitats as well. This is not the place to go through the recent decisions of the Court of Justice of the European Union, but it's necessary to emphasize that habitats law has become significantly more onerous in recent years, particularly around the standard of knowledge that is required to exclude adverse effects and the way in which mitigation can be considered within the application. My third practice point relates to fallbacks. I know this will be a live issue in the thinking of many promoters, and I saw again from the 2019 RUK paper that there is a drive for planning guidance which supports with wind farm scenarios as an EIA baseline. Now, the difficulty with that is that if your permission for the extents scheme is due to expire, then you're going to struggle to hold the with wind farm scenario as the realistic baseline, which you need to assess against. And an important consideration for many developers will be whether it's worth applying, whether you can properly justify a life extension as a way of locking in that with wind farm baseline before you then apply for a fuller repowering. Now that obviously adds additional cost and additional time, but it might in some circumstances make quite a big difference in terms of how you then end up having to justify the environmental impacts of your scheme. It's worth noting and reminding ourselves that, of course, the mere existence of a permission is not necessarily going to be enough to make the fallback material. In planning law, there must be a real prospect of the fallback being implemented. And under the EIA regulations, what must be described is the current state of the environment and an outline of the likely evolution thereof with that implementation of the development. So in EIA terms, you're going to need to be able to show that in the situation where you have acquired an extension permission, that it is likely that that will actually be used and implemented. So there may be issues around whether or not it's truly viable to keep a farm going, which will have to be addressed on a project by project basis. Final practice point, consultation. Now, of course, consultation is mandatory pre-application for onshore wind. For any, I think it's any schemes that have more than 2 turbines or have turbines of greater than 15 meters. So practice nearly all of the schemes that you're going to be considering. Experience from the pre-2015 days of onshore wind development in England demonstrates the sensitivity which turbines tap into or trigger in England. And the survey data on opinions to onshore wind, while it clearly shows a significant shift in views, is potentially still a fragile position. And overall, as an industry, I think it's probably worth recognizing that poor communications with local communities or overly ambitious applications may generate significant opposition, which in turn may lead to a turning again of the tide insofar as public opinion affects decision making in Westminster. Schemes which need to change red line boundaries may be particularly vulnerable to local authorities dragging their feet, forcing developers to go to appeal and go have an inquiry. But it's also notable that where dealt with sensitively, such as at Kirkby Moor, it is possible to bring locals on side, and at Kirkby Moor, a significant number of the local residents actually spoke in favour of the application at the inquiry. My final point, so those are my 4 practice points in terms of repowering. And the final thought I just wanted to leave you with is the importance under the current version of the NPPF of local development plans, but also the vital importance, in my view, of developers engaging with local authorities on their local development plans for whatever regime evolves in the future. Because to date, it seems to me that there has been relatively little engagement by the industry with that local plan process. And I'd be interested to know if there are others who have a different view on that, but that's certainly my perspective. And at the moment, it seems that national policy is not likely to change immediately, but the ongoing need argument for climate change, around climate change, does have resonance in local authorities and in local communities, and should, in my view, may well in the future give opportunities to persuade key authorities to designate suitable areas where there's particular potential for wind power and where the environment may be less sensitive. That may well continue to be a prerequisite for new schemes, even if policy does change. And it would seem to me that there's probably some benefit in the industry taking perhaps a couple of leaves out of the book of the housing developers and starting to engage with the planning process further upstream than it perhaps has done previously. Now that's my final point, and then I'm going to hand on over to Heather, who's going to be talking about the situation in Wales.
Thank you very much, and I'll hand over to Heather to deal with the Welsh experience. Thank you.
Thanks, David. So for schemes up to 10 megawatts at the moment, the decision maker is the local planning authority, and the decision making framework in Wales is the 1990 Act, Planning Policy Wales, TAN 8, the technical advice note, and the statutory development plan, and of course any other material considerations. So for schemes that are larger than 10 megawatts, these are now developments of national significance, and that means the practical difference there is that the decision maker is the Welsh Government, so the applications are made to PIND Wales, but the framework for making those decisions is the same as for smaller schemes. There's no upper limit because onshore wind in Wales was removed from the NSIP regime via the Energy Act 2016, and so since then the decision making framework's been completely devolved for Wales. DNSs were introduced by the Planning Wales Act 2015 in 2016, and the criteria for DNSs are found in the DNS Specified Criteria and Prescribed Secondary Consents Wales Regulation 2016, snappy title. So like the DCO regime in England in respect of NSIPs, the DNS regime is front-loaded. Once accepted, applications have to be determined within 36 weeks. Save in exceptional circumstances, and there's an emphasis on pre-application consultation, which has to last at least 6 weeks. So one might think that since the decision-making framework is entirely devolved, it's been plain sailing since then for onshore wind in Wales. Many of you, I'm sure, will remember that back in 2017, the Welsh Government issued a formal written statement setting out its public support for onshore wind and also for solar development, and noting in particular that the exclusion of onshore wind from the contracts for difference mechanism, being an exclusion by the UK government, had had a significant impact on development. in particular, there hadn't been any new applications for planning permission within the SSAs under TAN 8 during 2016. And it's interesting that the formal written statement was endorsed, not just, I mean, it didn't just come from the Welsh Government, it was endorsed by Natural Resources Wales, the Welsh Local Government Association, the National Trust and several other stakeholders. So just to summarise, before we go on to look at the draft development framework, what TAN 8 currently says, it deals with, primarily that is, with large scale onshore wind developments, which it defines as being over 25 megawatts, and says that those should be concentrated into the strategic search areas, or SSAs. 7 are identified in TAN 8. And then it's the job of the local planning authority to undertake local refinement within each SSA. And TAN 8 does say that local planning authorities might wish to consider the possibility of developing wind farms on suitably unconstrained land that is outside but close to the SSA. TAN 8 sets out indicative targets of installed capacity. They're not supposed to be the definitive capacity. It goes on to say that there might be practical, technical and or environmental reasons why the capacity may be more or less than indicated. And those indicative capacities are actually a third reduction on the maximum capacities that were identified by the Welsh Government's technical consultants. The purpose behind that was to allow local discretion in identifying the best sites within the SSA. TAN 8 also provides that most areas outside the SSA should remain free of large wind power schemes. So under TAN 8, that would be schemes of 25 megawatts or above. It encourages brownfield sites to be used for schemes of up to 25 megawatts. And it also says that local planning authorities should encourage smaller community-based wind farm schemes, but those are defined as being less than 5 megawatts. Importantly, it says that the Welsh Government will support local planning authorities in introducing policies that restrict wind developments above 5 megawatts to SSAs and to brownfield sites, and it explicitly says that it is acceptable for planning permission for developments over 5 megawatts to be refused if they're outside SSAs and not on brownfield sites. Although TAN 8 does explicitly encourage repowering or extending existing wind farms, it's, I suppose, interesting to observe that there is a distinction in TAN 8 between repowering and extension, which I don't think it's of huge relevance to people who are arguing about the position over in England, but if you did want to try and argue that they're two different things, then certainly TAN 8 seems to take that view. This is a summary of the position as at 2018, which were the most up-to-date Welsh Government figures that were available. And the short point really to take away from this is that as of 2018, 60% of the indicative target capacity identified in TAN 8 was operational. And there was a further 68% of that indicative figure that was either consented or in planning. So obviously you'll have worked out that if you add 60 and 68, you get to more than the indicative target capacity, but actually less than the identified maximum capacity. So that's where we were in terms of schemes being either in planning, consented, or actually operational. Although the difficulty with these figures is that the operational figures include both pre and post TAN 8 entries into operation. Just to mention a recent development in relation to the GARNVAC proposal, which is being promoted by EDF Renewables. This is a site to the south of Newtown, which was previously proposed for the Slife B scheme, which was one of the applications, I think 5 in total, that were rejected by DEC back in 2015, but that is now being promoted again. It's currently at the pre-application stage, and prior at least to COVID potentially disrupting matters, the submission of the planning application was programmed for towards the end of this year. So coming then to the draft National Development Framework, which is the focus for the rest of my presentation. This is to be the new spatial development plan, which is to set the direction for development in Wales from this year to 2040. It's the highest tier of the statutory development plan, and then the idea is that beneath it, it gets built on by strategic development plans at the regional level and local development plans at local planning authority level. It's going to replace the Wales Spatial Plan. Consultation on the draft ended back in November, but the Welsh Government hasn't yet published its response to the consultation responses that were received. The general targets that are set out in the draft for the generation of renewable energy are 70% from renewable energy by 2030, a gigawatt of renewable energy capacity to be locally owned by 2030, and I think really a quite vague requirement that new renewable energy projects are to have at least an element of local ownership by 2020. I'll check that figure, I'm not sure, that might supposedly have to say 2030. Large-scale onshore wind development aligns with developments of national significance, so the threshold proposed in the draft NDF is 10 megawatts and above, in contrast to TAN 8, which was focusing on 25 megawatts and above. The spatial priority is that 10 megawatt and above developments are to be directed towards priority areas for wind and solar energy. The approach that's proposed in the draft framework is a traffic light based approach, and this is a graphic taken from the draft itself. So going from the bottom up, green means that within priority areas for developments of 10 megawatts and above, there is a presumption in favour of development, and there's also an acceptance of the principle of landscape change. Then in the amber category, that relates to most areas that are outside priority areas. So for schemes of 10 megawatts or above outside of the priority areas, there's no explicit Welsh Government support, but it is open to promoters to make the case for their scheme. So on the face of it, it seems to me that this is a more flexible approach than the approach that's currently set out in TAN 8. And then the red category relates to the national parks and to AONBs in which large-scale wind projects aren't acceptable. It's a little bit difficult to see at this detail. This is where I really need a large projector with a big screen. But on the left-hand side, we have the position under TAN 8 with the squiggles A to G that indicate the existing SSAs. And then the right-hand side is the map of proposed priority areas from the draft framework. So in terms of a comparison, there are more priority areas proposed than there were SSAs. There are 11, the orange ones, I should say, the darker colour on the right-hand side represent the wind areas, and then the paler ones are the solar areas. As you can see, the priority areas together cover a much larger area than the existing SSAs. Some of them are similar in size to existing SSAs, but several of them are, as you can see, much larger, particularly in the south of Wales. And there is some overlap with SSAs, but there are new locations, so probably most obviously on Anglesey, south of Colwyn Bay, south of Aberystwyth. There's a much larger one now proposed north of Carmarthen, and the really big one at the bottom that stretches from Swansea over to Cwmbran. This is the detail from the draft framework about priority areas. They've been identified through a strategic review of landscape and visual impact as the most appropriate locations to accommodate landscape change. That's been the driving force behind their identification. But as you can see from the extracts that I've set out here, there's a real emphasis on the need to focus very carefully on the siting of specific proposals within the priority areas. A stated desire to protect communities from being entirely surrounded by large wind schemes, and an emphasis on the need to consider cumulative impacts in particular. This is the exact policy reference for the draft framework. It's policy 10 that addresses wind development in priority areas. So as we've seen under the traffic light system, there's a presumption in favour of development and an acceptance of landscape change. The other point to note is that the draft policy explicitly requires significant weight to be given to the contribution to reducing greenhouse gases and to meeting decarbonisation and renewable energy targets. But there is a requirement that the specific application must demonstrate how the environmental benefits have been maximised and the specified range of adverse impacts has been minimised. So that list of adverse impacts includes all of those that you'd anticipate. So landscape and visual, cumulative impacts, impacts on the setting of national parks and AONBs, visual dominance, shadow flicker, light and noise impacts, electromagnetic disturbance, and then matters such as archaeological, architectural and historic assets, nature conservation sites, and so on and so forth. We will see that in addition to national parks and AONBs, Natura 2000 sites within priority areas are excluded from the presumption in favour of development, so habitat sites, and the Welsh Government has said that it will produce further guidance in relation to these priority areas. Policy 11 is then the policy that deals with the amber category, so what is and isn't acceptable outside of priority areas. And then the final policy in the set is policy 12, which just makes the point about national parks and OMBs. So that is a quick tour through the recent position in Wales, where essentially, in a nutshell, the policy and the legislation has been supportive of wind, as has the government in principle, but the absence until recently of the CfD mechanism has been, I think, probably the key obstacle in bringing schemes forward. As Rebecca's explained, hopefully that's changing from the promoter side of things, and it remains to be seen how the proposed framework might be more effective than were the SSAs in enabling sites to be identified and promoted through to production of wind energy. So I'll hand back to David, who's going to tell us about the position in Northern Ireland.
Thanks, Heather. I'm going to explain briefly the position in Northern Ireland. That there isn't as yet any specific policy guidance, either in RDS Regional Development Strategy form or otherwise, which deals specifically with the issue of repowering. So this is just going to be a quick reminder of current policy, but it's worth noting that, for example, Scottish Power, who operate 5 of the wind farms in Northern Ireland, including some of the oldest, Rigged Hill in Limavady in County Derry and Corky Wind Farm in County Antrim, both of which date from the early 90s and have fairly low power collections of 10 turbines each, have both subject to applications for repowering, to add, in the case of Corky, 5 new turbines, which will add to the existing 10, which produce 5 megawatts maximum at the moment, which will allow that wind farm, if consented, to take capacity to 20 to 25 megawatts. And at Rigged Hill, again, 10 from the early 90s, generating a maximum of 5 megawatts, but with 7 new turbines, which will add up to 30 megawatts capacity for those. So out of their 5 wind farms, they've taken the 2 oldest with the oldest technology and are pursuing applications. Those and any others that come forward will have to be considered in the light of existing policy. As I say, I will do a refresher on current policy on wind development. The oldest existing policy is PPS 18. I'm sorry, it was incorrectly referred to in the publicity as PPS 8, and some of you may have scratched your head and wondered why open space and recreation policy came to the forefront, although it's of course relevant. It's PPS 18. It sets out what you'd expect, the benefits to the Northern Ireland economy, the need for greater use of renewables, the reference to the then strategic economic framework, and setting out the objectives of renewable energy. The key policy in PPS 18 is RE1, and it sets out the considerations you'd expect it to set out in terms of the planning factors, public safety, human health, visual landscape, amenity, biodiversity, built heritage, which covers both historic sites, both the built nature and archaeological, natural resources, public access and the like. Tourism, of course, is also an important issue. But note, it gives significant weight to environmental, economic and social benefits of the proposals. And that's a phrase of some importance because it figured quite importantly in decisions up to the introduction of the SPPS in 2015, which has modified the weight requirement. Whether that makes a difference in practice is another matter. RE1 has a separate, a special section to deal with wind energy development, and again, it covers the factors you'd expect it to cover, and I'm not going to read them out. They're there for reference should you want it. And there's a special concern which is replicated through other policy guidance on wind turbines about development on active peatland because of the impact, of course, in terms of the ecology of the peatland and also the carbon storage elements of peatland. It also refers, as does virtually all the other guidance, to the landscape supplementary planning guidance, wind energy development, which should be taken into account in assessing all wind turbine proposals, though it's not meant to be prescriptive. As I've mentioned, PPS 18 is replicated to a significant degree, though in less detail, in the SPPS. And it notes, as does policy in England and Wales, the inevitable impact in visual and landscape terms and how that should be dealt with. More on that in a moment. You'll find that the best practice guidance, which was published at the same time as the PPS and is to be read with it, makes rather stronger statements about the factors, including the visual factors. And there you see there is an acknowledgement at 1325, wind farms, stating perhaps the obvious, will normally be tall, frequently located in open land, therefore often highly visible. It's to be expected that they will have a visual impact. Wind energy SPG sets out very detailed guidelines on landscape and visual assessment, including a methodology for the assessment, how to formulate applications, and setting out detailed information relevant to each of the Northern Ireland landscape character areas, and has as an aim the facilitating of the siting of renewable energy generating facilities in appropriate locations. The character areas you can see are many, and there is guidance relating to assessment and the characteristics of each of those. Some of these are more sensitive than others, for example, those in the areas of outstanding natural beauty. Just moving the slide on. Other policy, note that PPS guidance, of course, predates the SPPS, which applies to the whole of Northern Ireland, was introduced in 2015. The PPSs, with some exceptions of those that were cancelled, are retained on a transitional basis by the SPPS until the new councils established and who are subject to the Planning Northern Ireland Act 2011 have got their new policies in place. There are development plans applicable, but most of them predate the SPPS, I think, apart from the Northern Area Plan from recollection. The transitional and retained PPSs will cease to have effect when new plans are adopted, and there are also provisions as to reconciling differences between the older PPSs and the SPPS. And so there are a number of policy documents which may remain relevant to wind energy application, in particular natural heritage, planning, archaeology and the built heritage, open space and tourism. Coming to the Strategic Energy Framework from 2010, that sets out the sort of economic imperative of, and indeed the environmental imperative of obtaining energy from renewable resources and making sure that the resulting economic opportunities are fully exploited. And there are 43 actions set out across 4 strategic goals, and you'll see that they're referenced in part, although given our current situation with Brexit and the particularly difficult position that Northern Ireland finds itself in, it's relevant to note that a number of the action points involve EU-related matters. Then, importantly, the RDS, the Regional Development Strategy. I've said 2010. It's actually dated 2010 on the copyright notice, but it was actually published in June 2012. It's a mandatory consideration in the formulation of departmental policy under Section 1 of the 2011 Act, and in the formulation of local plans under Section 5 of that Act. And it contains both regional guidelines and spatial framework guidance, which is relevant, and you'll see some examples there. RG11, built heritage and natural environment, SFG 13, sustaining rural communities living in smaller settlements and the open countryside. And it refers, I should have mentioned this earlier, to the target of 40% renewables in the SEF. and noting this is likely to mean an increase in the number of wind farms, which in fact has proved to be the case both on and offshore. Note, however, that although it's a target, it's not a ceiling, and although it has been argued at a number of appeals and hearings that 40% having now been met and exceeded in Northern Ireland, that no more is required. That's not actually the proper construction of the RDS, which is setting the target, but of course with carbon reduction policy in mind, of course, it's not to be regarded as a cap. Then you have the SPPS, as I mentioned, in 2015, Strategic Planning Policy Statement, and it, of course, has a distinct section on renewable energy, again, reiterating the policy that is seen in the earlier documents and in the RDS. And the aim is said to facilitate the siting of renewable energy generating facilities in appropriate locations. And of course, the appropriate location is always the difficult point as to finding a location where the impacts are sufficiently acceptable to be outweighed by the economic benefits, because as in all cases, there are likely to be some impacts. And note, under regional strategic policy, quite importantly, certainly very differently from the position in England under the NPPF, where areas of outstanding natural beauty are subject to very much more stringent requirements for exceptional circumstances for development. The SPPS says at 623 that a cautious approach for renewable energy development will apply within designated landscapes which are of significant value, and lists them, noting it may be difficult to accommodate renewable energy proposals without detriment to the cultural and natural heritage assets. So that note, although it's not put in strong terms, marks, certainly in my view, in my experience, a rather different approach to wind energy in the Northern Ireland planning system than it does, for example, in the English planning system, where those features are given very strong protection. And it appears to take, in policy terms, a line which comes out of the best practice guidance of PPS 18 and doesn't, as in the NPPF, make it significantly more difficult. And then further issues in relation to the planning considerations, which will apply to repowering as they will to any other applications. If you're going to add additional turbines, or if you're going to replace turbines, siting, impact, all of those matters will still come back into play. And what will be relevant, bearing in mind the guidance, the current guidance requires consideration to be given to limited lifespan and to decommissioning, is the difference that may apply to those that have perpetual permissions and those which have permissions which are subject to time limitation and decommissioning. It's interesting to note that the two examples I gave at the beginning, Rigged Hill and Corky, both of them being early permissions are perpetual, and so they're not subject to the same restrictions, and it will be easy to argue a fallback position, I suppose, with those cases and say, well, we've got existing turbines and they're not going, therefore you need to judge the impact, against those where they're subject to decommissioning requirements, where the impact is intended to be shorter term, and it may be more difficult to argue you should take account of the existing turbines in looking at the repowering provisions, because they're intended to be more time limited. It provides a more complicated balance than in ordinary cases. Note at 625, the significant weight of PPS 18 SE1 has become appropriate weight. And then again, the visual impact issue, and again, a reference to the landscape guidance. Just a few notes briefly. You'll see from the statistics generated by the Department for Economy and the Statistics Agency. Oh, sorry, I didn't mean to go that fast. You'll see that over the last year that it produces quarterly rolling 12-month figures, and you'll see that the percentage of renewables in Northern Ireland is high and has exceeded the 40% target in the SEF referred to in the RDS. And you'll see that it's exceeded 40% since July 2018, and indeed The last statistics issued in March showed the highest rolling 12-month percentage on record, 46.8%, and consistently in recent statistics, wind power has provided the lion's share of the renewable contribution to energy. And I've given you the figures from March 2020. The next statistics, which are bound to be skewed by the crisis currently being experienced, where, of course, a lot of power now being generated is non-fossil fuel because of the the drop in requirements for power in businesses and the like over the lockdown period. What the position is going to settle down as after that, of course, remains to be seen. But I suppose one expects to see a higher percentage, a much higher percentage of renewals in the next quarter. And there you see in graphic form the percentage of wind in the pie chart at the bottom, which is in the same document, which is note 15. Finally, just some examples in decision making. They provide, and I've given 3 examples, ABO Wind, Dunmore and Bar Craig over the last 4 or 5 years. You see there that the issue of benefits being weighed against landscape impacts, they're all cases judged on their own merits and have to be read as such, but you do see the interplay in the various factors in the policy that I've highlighted. The same will apply to repowering, subject to those points I made earlier about the difference between perpetual consents and those subject to decommissioning. And I draw attention to the fact that Northern Ireland's largest wind farm, proposed at Doraville in the Sperrins AONB, is waiting decision from the Minister. We had a hearing in September of last year, which was fully attended and participated in by local people and other groups. 33 turbines were proposed, 23 at a maximum tip height of 149 metres, 10 at 136, with the usual provisions proposed as to micro-siting. The Commissioner is noted as having reported to the Minister in February, I think, but no decision as yet. Thank you very much. And if everybody would unmute their microphones on the team, please. And I'd like to start dealing with some of the questions, and we'll deal with as many as we can before we run out of time. Matthew, can I ask you to kick off, please, with the question about the need for regional targets, please?
Thank you, David. Thank you. So there was a question asked about whether or not there needs to be some form of regional policy or specific targets allocated through planning policy to encourage local authorities to allocate areas for wind farms. And I mean, it's a general point, but I mean, I think the experience of how slow local authorities in England have been to put forward areas in that way suggests that something needs to be done. I mean, I don't know if other members of the panel have other views about the right way to get it done, but I would have thought that something in national policy is really needed to provide a mechanism by which local authorities can be forced to calculate, you know, what sort of provision they should be making in their areas. So a good idea in principle, but unfortunately, I'm not sure we can hold our breath on that one. I was also asked there's another question asked, which I think is perhaps related, which was about the
yes, the issue of climate emergencies and the lack of coordination between local authorities declaring climate emergencies and not making provision for renewable energy to reduce carbon emissions.
Yes, I mean, I think that, you know, the point there is, I mean, I think that the questioner wanted to particularly ask whether or not that was a rational, it was a rational position to take, to declare a climate emergency and yet not allocate areas for wind turbines. And clearly, rationality is a very difficult standard to meet in the courts. It's very hard to show this local authority has behaved irrationally. But we know from other case or ongoing cases that there are a number of areas where as in the Heathrow situation, a failure to take into account what you're doing in other fora can get you into trouble. So one issue I think you'd want to look at on a case-by-case basis is whether or not the council's thinking was properly joined up in that way. And there are also other examples of the client earth litigation in the air quality context, where failure to meet broader standards has got somewhere, but it's going to be very difficult, and you're going to have to look at it very much on a case-by-case basis, I think.
Thank you. Rebecca, can I ask you to answer the first question we were asked, which was just to explain a little more AR4 and the pots?
Yeah, sure. So the CfD is separated into pots, and that's about which technologies can compete together in the auction. So each pot basically has its own auction, if you like. So in this example, in pot 1, onshore wind would be competing with solar. And it's also about what is allocated to that pot in terms of budget, and also the other parameters. And what we mean by that is kind of the rules of the auction. So it's for funding, but it's also how that auction will work.
And we've also been asked, and I wonder whether you have any views about issues of community benefits and how that might be taken forward.
Was that specifically in relation to was that in relation to the consultation itself in that question?
I'm not sure, but can you answer it by reference to that?
Yeah, so in terms of what they'll do with community benefits, I think in the first instance, what's set out in the consultation is really a sort of a fact-finding mission to understand the different approaches and the different devolved administrations and examples of best practice. So I think this is kind of responding to the needs of communities, as I said, but also the desire to ensure that policymakers are well informed about what's happening on the ground. And there's some really good examples out there of where particular wind farms have made really impressive contributions to their local community, not just through community benefit payments, but through a really sort of tailored offer which meets the specific needs of those communities. So it's not clear yet how that conversation will be taken forward, but certainly the consultation was the first stepping stone in that conversation.
Thank you. Can I turn to Heather for some questions relating to Wales, please? Heather, do you have a comment to make with regard to, particularly with regard to national parks and AONBs and landscape and visual assessment, the issue of setting, please?
Yes, we've had a question as to whether the draft framework clarifies that issue about the setting of national parks and AONBs. It doesn't really. There is an explicit requirement in draft policy 10 that an application has to show that adverse impact on setting of national parks and AONBs has been minimised, but it doesn't expand further beyond that at the moment. I assume that might be one of the issues that the government's proposing to explore in the guidance that it has said that it's going to issue. I mean, the other point I'd add on the draft framework is that it is, of course, in draft at the moment, and a range of views have unsurprisingly been expressed in the consultation responses. There are those who consider that the traffic light system doesn't go far enough, in effect, because only limited areas are identified as priority areas and given the presumption in favour of development and the acceptance of landscape harm. And I know there's also an argument that drawing lines on maps is simply unhelpful, particularly because it generates ill will from the communities who find themselves within those lines. So there are stakeholders calling for an approach that dispenses with lines on maps and adopts a set of criteria that applies to all locations equally. It remains to be seen whether those arguments will win the day. It seems to me what the Welsh Government's doing in the draft framework, in effect, is saying the adverse impact that we think is preeminent in relation to wind development is landscape impact. So we've explored that impact, and we're setting out in the framework our view as to which areas are most suitable from that landscape perspective. And of course, there'll be those who think that's a sensible approach, and there will be others who think that landscape impact shouldn't be elevated, as it were, and dealt with at the national policy level in a way that other adverse impacts aren't. So it'll be interesting to see what the ultimate outcome is. Thank you.
Let me turn to Northern Ireland, and firstly, an apologies for my mispronunciation. I'm afraid it's my northeastern English. It gets in the way. Can I deal with the question about increasing possibility of appeals in Northern Ireland? And it's asked by reference to the Dumbeg wind farm, which is one of the first located in a statutory protected landscape. I mean, I agree that there is a lot of pressure being put on landscape because of the large amount of landscape in Northern Ireland protected for its natural beauty, and indeed in some cases for its historic significance, and it's part of the setting of heritage matters such as archaeology. And indeed, one of the issues in the Doraville case in September was the setting of stone circles from which the tips of some of the rotors would be visible over the hills in the Sperrins, although it was located outside of the valley in which the turbines were proposed. But given that planning is significantly in the hands of the 11 councils now, it may well be that there is less appetite for consenting, though I've seen plenty of examples of consents granted by local authorities, and it may also turn on the final version of new local plans being brought forward. But I wouldn't be surprised if there were more appeals on these issues, and indeed in some cases where the department gives notice that it's to be dealt with by the department rather than the local authority, if there are, of course, of more than local significance, which may often be the case if the department thinks so, given the landscape protection issues. Rebecca, can we come back, please, to Matthew, rather? Can we come back, please, to Section 78 applications, which is the subject of a question earlier on?
Thank you, David. I think the question was about Section 73 amendment applications. So the questioner says that they've been progressing some extension applications under Section 73 to vary the time limiting conditions on the permission. And the question is whether or not pre-application consultation is required in respect of those applications. And the answer is no, it's not. The Development Management Procedure Order expressly excludes Section 73 applications from the requirement for pre-application consultation. I think that's para 3.2 for our questioner. So no consultation required there. That might be seen as an incentive to try and use Section 73 creatively, but of course we know now that there are various risks in trying to broaden the scope of Section 73, and I'd refer him to the Finney decision, obviously, which will have an impact where you're not just changing the time limitations.
Thank you. I think we need to curtail questions at this stage due to time, but as I said to everyone earlier, what we'll seek to do is remaining questions that we haven't been able to answer in the available time in the live session. What we'll do is we will compile answers to the remaining questions so far as we're able to and circulate them by email over the next week or so. And also whole of the presentation will be available, including the slides, will be available on YouTube, and a link will be sent to everyone who's registered for this webinar this morning. Can I thank all the speakers, particularly Rebecca, for joining us and the Landmark team, and can I thank you all for joining us, and hope you found it useful. Thank you very much.